And I think as Mike just highlighted, today our panel is going to be providing a deep dive into public-private partnerships, what we're calling P3 2.0 for ACIC. Our goal is going to be to provide you with a more robust understanding of how P3 transactions work, both from a structural and legal liability standpoint. So we're going to be dispensing more quickly at the outset with just the general broad strokes of what a typical P3 is, and spending more time on the finer points of transaction structure. And to do that, we're going to be focusing on three primary areas of relevance. And conveniently, we have three experts in the industry to walk us through that. Mike Pickell of Winston is going to be walking us through the procurement process. And you know, as many of you know that have worked on P3s, this is a very, very different world than your typical senior unsecured or even secured deal. So Mike will walk us through that. Then we're going to turn it over to Paul from Epstein from Sherman and Sterling, who is going to walk us through primary contract structure in terms by looking in particular at concession agreement terms related to typical risk allocation, relief and delay events, compensation events, termination events, and lender rights. And then Dave Lasota, my former colleague, is going to round things out for us by taking a focused look at construction, in particular construction security options, by taking a look at payment and performance bonds, letters of credit, expedited dispute resolution bonds, and liquid surety bonds. And then time permitting, fingers crossed, we hope to be able to walk you through just a current market overview of what I think has dominated most of our lives for much of this year, which is COVID amendment waivers and terms in the P3 space. And then we'll have questions at the end. And on that point, I think Mike and Patty had probably walked through earlier that we'll have the running questions that you can submit throughout the presentation. But just like as if we were in New York, in real life, I'm going to wait until the end to take those questions. We're not ignoring you. I'll take them down and we'll have the 5 minutes at the end. One more item, I've been asked to remind you that there's going to be two course codes. I'll provide one shortly. There will be another toward the end of the presentation. Write them down, keep them near and dear to your hearts. You'll need them for your CLE credit. And so please with that too, send in your CLE affirmations to CJ at cle@aciclaw.org by Monday, October 19th for your credit. And with that, I'm going to turn it over to Mike, Mike Pickell, who's going to actually walk us through a quick refresher of what a P3 is to get us acclimated for the day. So Mike Pickell, take it away.
I'm not able to, can you hear me?
Yes.
Can you hear me? Okay, all right, good.
Now we can.
Thank you. So I think the idea of public-private partnerships or private participation in the delivery of public infrastructure is nothing new. This is something that's been going on for centuries in parts of the world. The idea of it in the United States is somewhat newer, I guess, like the United States itself. The first modern P3 in the United States could probably be traced back to SR 91 in California. But there's obviously been quite a lot of improvements in the market, and the market's expanded quite a bit since then, which that transaction occurred in the 90s. So gonna flip slides. There we go. A lot of you might be wondering just what exactly is a P3 or how is a P3 defined? Those of you that follow the infrastructure industry trade press see a lot of transactions reported or covered by the media, and you're often wondering, well, what exactly is a P3 and what's not? Because there are a lot of transactions or deals that are referred to as P3s. There has been, I guess, some attempt to try to standardize the definition across the world. You know, the World Bank as well as certain national P3 organizations have tried to come up with some definitions. You know, so I've put a few of them up here on the slide for you. But the way we like to think of P3s at Winston or PPPs is just that it's a contractual arrangement between a public sector entity and a private sector entity that allows for greater private sector participation in the delivery of a critical public infrastructure asset than what might otherwise be allowed in traditional delivery methods. So thinking about some of the main characteristics of a P3 or PPP, and I think Paul's going to get into some of this when he talks about concession and project agreements later, but it's risk sharing, a long-term relationship, and the actual public service or the regulatory responsibility remain with the public sector. The private sector skills are there to help deliver the public sector services. In terms of what are some of the key elements of a successful P3, we're going to be talking a little bit about the procurement process, but a very important one is a transparent and competitive procurement. Political commitment is important. You'll often, unfortunately, there have been cases where projects have been canceled or procurements have been canceled because there hasn't been a political commitment to see things through. So those are obviously important characteristics. In terms of benefits to the government, there's a number of them. There are people who think everything is done best by government, and there's probably a lot of evidence to the contrary, but P3s do tend to improve service delivery. They tend to improve cost effectiveness. There is risk transfer. The costs of design and construction are transferred. The cost of schedule and time overruns is transferred. Oftentimes market demand is transferred. There's budget certainty, faster delivery, and the concept of value for money. In terms of, what is a P3 and what isn't, there's a slide up ahead. There you go. With kind of a spectrum of the types of delivery methods for public infrastructure. And as you can see, on the right, as you get more, higher risk transfer and higher private sector participation, it's the types of transactions that we're talking about here. I'm going to spend just a minute talking about a typical structure. So here on this slide, we've got what's the typical structure for an availability payment-based transaction. And some of you might look at this slide deck and think, well, gee, that kind of looks a lot like a power project. I'm used to lending into power projects, and that is actually a pretty good characterization. One way to think of it is that the procuring authority is like the off-taker, and the project agreement is like a power purchase agreement where the output is purchased by the public sector in exchange for a performance-based fee. Contrast that a little bit with a typical structure for a revenue risk transaction, such as a toll road. The concession is granted by the procuring authority, but it's the end users who are ultimately, generating the revenue for the project company.
And so guys, now I'm going to just give you the first course code before we turn to the procurement process. And that is 73496. 73496. Sorry for the interruption, Mike. We'll let you continue.
That's okay. Code is very important. So next, we're going to just talk a little bit about the procurement process. Sort of run through some of the stages here of what a typical project procurement looks like. It really starts with the planning stages, and that can take years. Many of us are not following a transaction yet or a project yet when it's going through the planning stages. It really becomes public when, and this doesn't happen all the time, but I'd say in most instances it does, the procuring authority will issue a request for information or some kind of a solicitation for requests for interest from the private sector to help them shape and scope the project. So they'll ask a series of detailed questions, they'll do market soundings, and then they'll take that feedback usually to an industry forum where they invite participants from design and construction firms, operations and maintenance firms, as well as equity investors, consultants, MBE firms, other subcontractors to come and hear about the project and provide some feedback. Sometime after the industry forum, the authority will usually issue a request for qualifications, which they'll use those responses to shortlist a number of pre-qualified bidders who will then be the only entities that are able to receive the RFP and submit proposals. As we've seen things transition over the last 10 years in the market, 10 years ago, RFPs did not require committed financing as part of the financial proposal. I would say now that the committed financing is required in probably 99.5% of the procurements out there. And the RFPs have gotten a bit more detailed in terms of the evaluation criteria as it relates to financing structures. So, and I think those of you that have worked on some of the Australian issuances in the US market probably know this. Transactions without refinancing risk tend to be evaluated more favorably than those that have refinancing risk. So a long-term solution like a private placement is given greater value than a solution that needs to be refinanced in a few years. The RFPs, particularly here in the US, have gotten more focused and more detailed when it comes to what's actually required with respect to the financing. When committed financing wasn't required, a high-level term sheet and a support letter from a lending institution would do. Now, there are a number of requirements about what's in the commitment letter, what needs to be covered in the commitment letter, and what kind of confirmations you need as to the approvals that have been obtained, as well as the diligence that's been done. And then another important feature is there's usually a validity period that's required, and that validity period tends to be, you'd like to see it at least as long as the validity period for the financial proposal. So if a developer's proposal is required to be valid for 180 or 240 days, developers need that 180 or 240 days from their lending institutions as well. They also will tend to ask for a cushion on that just in case there's delays. The RFPs also have specific requirements as to what's in the term sheets. So flipping that. So obviously you need a description of the amount and size and type of the facilities, but there also needs to be some kind of a description of the conditions precedent, as well as the rep's warranties, covenants, and events of default, repayment or prepayment terms, description of any reserve requirements. You need to look at the term sheet and understand the method for determining the interest rate, what fees are payable, and then understand what the collateral arrangements are. As these criteria in the RFPs have evolved over what's required in a debt term sheet, it's really led to considerably detailed debt term sheets. So you see a robust commitment letter with a number of confirmations about due diligence and approvals that have been obtained, and then you see a term sheet attached to that in some cases is 75 or 85 pages long and doesn't really leave a lot to be desired in terms of what's left to the note purchase agreement. So it does take a fair bit of effort in terms of negotiating the term sheets and the commitment letters and getting through credit processes and rating agency processes as well. And that's also one of the things that you see in the RFPs now is that the procuring authorities want to see the indicative ratings that you're obtaining on your debt. So those rating agency letters do need to usually be submitted with the financial proposal. So there is a whole rating process that's going on at the same time that the commitment letter and the term sheets are being negotiated. So what that means for institutional investors like you all is that the process here is a bit different than a traditional private placement issuance. So instead of just going to market with a term sheet or a draft note purchase agreement and soliciting bids, and there's a whole process that goes on where that's sort of done based on a commitment letter and a term sheet, and so people are asked to submit comments, and this is all within the construct of the RFP process, where there's no certainty yet as to whether or not there's even a deal there to be done for the developer. The developer is running a process where they're soliciting feedback and having a competitive process among institutional investors to get the best terms, for their proposal. Then they have it's sort of similar to a source code. They'll build a book of their investors, as part of the RFP process, and then get investors to sign commitment letters prior to submission of the financial proposal. So that's a bit different than what you would typically see, obviously. And then if that developer is awarded the project, then there's then they move to drafting the documents. And in an ideal world, there's not a lot left to do between taking one of these detailed 85-page term sheets and turning it into a no purchase agreement and security document. So the process is a bit different.
Great. Mike, I think you cut out, but can you hear me? I think we're toward the end of that anyway. So I don't think we can hear you, Mike. Dave or Paul, if you can hear, can you hear Mike?
I was just going to say, I think that was the end of the procurement process.
It is. So it was a perfect time for you to cut out. But we had one question, but just to sort of reiterate, right, for the group, that this is a very different process, and you touched on that at the end. That folks are sort of running with a developer or sponsor group and negotiating documents right before there's any deal to be had, which is very different than what we see. I think we're talking over each other. So thank you, Mike. I will turn now to Paul Epstein, who's, as we said, going to walk us through a deep dive into concession agreements and giving us a look into the primary doc term structure there. So Paul, take it away, sir. Paul, can you hear me?
Can you hear me now?
I can.
Good. Yeah, sorry.
Yeah, we're ready for you, sir. Take it away.
Thanks again. So one of the key documents that gets negotiated as part of this RFP process that Mike described is the concession agreement. It's definitely, I totally agree with Mike. It's akin to, generally akin to an offtake, certainly in an availability payment structure, where it's a payment stream that's being effectively monetized over a period of years, subject to the availability of the asset. This document goes through several rounds of negotiation during the RFP process, and we work together as lenders counsel. We work together with sponsors counsel and with you to get terms that reflect an appropriate risk allocation for the lenders. The sponsors are meanwhile working arduously to get to achieve an appropriate risk allocation for their equity interests, and it all comes together in a crescendo with the final RFP and the bid at the appropriate time. I'm going to dive a little into the structure, the general structure of the contracts related to the concession, and then address some of the concession terms themselves. So just like the well-known adage that once you've seen a project finance deal, you've seen one project finance deal. Each concession is negotiated bespokely among the relevant investors and the university. The specific parameters of the allocation and degree of risk transfer is really a basis of whatever the procurement structure is. If you remember the continuum that Mike set forth from DB, DBB through to DBFOM, it's a difference in risk transfer and effectively allocation from public to private in each of those models, and the concession reflects whatever that allocation is. The nature of the project is the other key variable here in terms of how the concession agreement ends up being structured and what the degree of risk allocation is. This slide that you have on your screen now is a variation of the one that Mike showed, and shows the passage from the granting authority, which is in the upper right. Sorry, it may not be entirely visible, but the public sector granting authority, which we've been talking about, is the procuring entity, passes risk to the project company, and the project company thereon passes risk to the parties best able to handle design and operation responsibilities through subcontracts. You might ask, well, isn't this all, why are we talking about a bespoke allocation? Isn't this all settled in a standard US form of concession? Well, the answer is no. It's not in the lawyer's interest to develop those forms per se in all situations because we negotiate one for each deal. But the reality is that each jurisdiction that have done P3s has developed its own preferences in connection with the relevant project, and there is no national model. There is in other jurisdictions, and we can talk more about maybe in a separate session how that stuff has played out over the years. But in the U.S., there are some basic parameters in terms of how a concession is structured. For example, whether a deal is a brownfield transaction where mostly what the concessionaire is doing or the developer is doing is taking over the assets, a turn over the keys type of transaction, and then managing that concession over a period of years, versus a greenfield deal, which all of you are familiar with, a project financing like a power plant construction arrangement where you're building a facility or building improving a facility and then operating once construction is done, operating that facility over a period of time. And we'll talk a little bit more about the permutations there. The other variation is whether it's a revenue risk deal where the concessionaire is taking demand risk versus an availability deal along the lines that Mike was mentioning. A lot of you may have been involved in where it's a relatively straightforward situation where so long as the asset is available, the developer doesn't take user risk or collection risk. The one other thing I want to mention here, the key for risk transfer is that in the pass-through, basically the construction and operating agreement are essentially pass-throughs of the key material obligations with respect to construction and operation that the developer inherits from the public sector. It passes through effectively in a contract, which often mirrors the concession to the design build contractor and the operating contractor. In exchange for that, there are certain rights that the subcontractors benefit from. Number one, so-called pay if paid. And this isn't a benefit, but a necessary element of the pass-through where the contractors only get paid under their contract to the extent that the developer gets paid under the project agreement. Second, what we call equivalent project relief, and this is a benefit. The subcontractor is entitled to whatever rights, if they have a right under their subcontract, and the developer also has that right to make a claim or what have you for some of the events that we'll talk about, events outside of their control, then they're entitled to press that right to the developer, which is then obligated under the subcontract to assert those rights vis-a-vis the granting authority. Equivalent project relief. Those are the important pass-through points. So let's go to the next slide and talk about risk allocation. This grid, which I encourage you to study at your leisure, is a basic allocation of risk for a P3. And this differs from a design bid build methodology where the granting authority will allocate each individual risk to an individual contractor under a single contract. The P3 agreement is an omnibus agreement where they allocate multiple types of services down and they allocate significant risk to the private sector. In exchange for that, the private sector agrees to take on the risk, obviously take the reward, and then share, each party agrees to share certain risks. So this grid allocates, sort of displays how in a typical deal, and this is not every deal, how the public sector may allocate its risk. Now, the public sector will traditionally retain things like right-of-way acquisition. Not all of it, but a lot of it. The risk of discovery, I'm looking at the left column there, public sector. Risk of discovery of archaeological, paleontological, or cultural resources, and virtually all types of change in law that are within its control. A lot of shared risks, permitting, design and construction changes. If something has to change order risk is shared, whether it be suggested by the authority or the contractor. The risk during construction, for example, hazardous materials are discovered on the site, typically a shared risk. If it wasn't known to the contractor ex ante, and it's on the site and couldn't have been discovered with reasonable diligence, then the authority will take the risk. But otherwise, the contractor generally takes the risk other than maybe third parties that are within the authority's control. Utility relocation, again, a shared risk. If an utility has to be moved, developer enters into agreement with the utility provider, takes the risk of compliance, but non-cooperation occasionally is a risk taken by the authority. And then a lot of allocated risks to the private sector alone in the left column. I think if we move to operations, that's all allocated to the private sector. Typically, operations maintenance, including life cycle risk, life cycle maintenance risk. And then there are a handful of things which we're going to talk about next that we call event risk, things that happen, many of which are unexpected during the life of the project and have to be accounted for from a risk perspective. Force majeure, including pandemic, for example, which is a new hot topic this year, and how that gets played out. Relief and compensation events. Termination events, which are sometimes in control of the parties, other times just a result of things that go wrong in the project. How do those risks get allocated? And then change in law, which we talked about. For the financing is typically allocated to the private sector. The implementation thereof, sometimes, as Mike mentioned, some market conditions are shared. Maybe moving to the next slide. We'll talk about some of the event risks briefly. So we talked about, relief events and delay events. You see it called both ways. Frankly, delay event is a brownfield form term. There's a form. And I should add, if there's a form in the US, it's brownfield. There is a model that's generally been used that does play itself through a handful of deals, both in the transportation sector, water sector, and now in the district energy sector for certain monetization style deals. Relief events outside of the control, they're completely outside of the control of the concessionaire, and sometimes there's a standard they couldn't have been avoided. This slide shows some of the key ones, including pandemic risk, which we talked about. Maybe moving to the next slide. Some more relief events, things that are outside of the control that relate to the construction process or the authority's role therein. And this is a list of additional events that you won't see in the brownfield deals that you will see in the greenfield deals. Hot topic for lenders. Next slide. Remedies. So the lenders are concerned that there are appropriate remedies in place for its borrower or issuer if something goes wrong outside of its control. And basically, there's a very detailed methodology and process set forth in the concession to establish the existence of the event, the compensation due, if any, which we'll talk about in compensation events, and any other remedy. So for example, relief events outside of their control, you'd go to the authority and the authority would effectively respond within a certain period of time and set forth an appropriate delay in compliance with performance obligations or a delay in a relevant milestone or completion date. There are special remedies, moving down in the slide here. There are special remedies for, sorry, you can go back, sorry, Alana, go back to the previous slide. There are special remedies that exist both in the brownfield and greenfield deals to deal with what we call extended delays beyond a reasonable period that really have a material impact on compliance or the value of the concession. And then the remedy differs a bit between greenfield and brownfield, and we set forth here the difference, but essentially they entitle you to compensation or in some cases termination. The next couple of slides are compensation events, and the main idea with compensation events is they're a subset of the relief events where the authority has decided that it's an appropriate risk for them to take on the risk of losses, whether revenue or incremental costs. And they're generally a subset of the relief event, so we don't have to go into the specifics here, but that's the main idea. We move to the next slide. What's the remedy? Key for lenders. In most deals, the remedy is that in the case of a compensation event, the granting authority is required to restore the concessionaire to the economic position it would have enjoyed if the compensation event had not occurred. And you might ask how that's developed. Well, a number of deals have reached the conclusion that it should be a no better or worse standard, where you look at something concrete, like the ratios and the equity IRR and the financial model that's most recently delivered, and you assess the before and after and determine the delta between the before and after and the compensation is that delta. And that's the basic regime for compensation events. Again, oversimplifying, but just giving you the basic ideas here. So lender rights, if we move to the next topic, obviously pertinent for note holders. What we've done in these next two slides is effectively show you what the basic regime looks like, the basic interface between the lender note holders, lender/note holders, and the granting authority on the one hand, and the contractors, the subcontractors on the other. And this is accomplished generally, deals vary, but generally through a direct agreement between the collateral agent and the relevant entity, where the collateral agent gives assurances, the relevant entity gives assurances to the collateral agent that their rights are as set forth in the concession or the contract, and they can step into the shoes of the developer or the contractor. They can step into the shoes of the developer if something goes wrong. And what happens is there's a detailed cure mechanism set forth, outlining the period of time to step in and or substitute in the case of a foreclosure, and the option to enter into a new agreement on the same terms as the existing agreement in the case of a rejection in a bankruptcy proceeding. But material rights to the lenders, and this is the interface. So it's very important when we represent you guys to effectively ensure that these terms are market standard, and give you the rights that you want in the case of a deal meltdown, where you have to step into the deal or assign the deal to a transferee. And that's these next two slides. So if we move then to termination events, I know we're running a little bit tight here, and Monica, let me know if I'm seeping into dangerous territory here. But on termination events, very important for lenders, right? Again, this is an end game scenario, not a cure scenario like a direct agreement, but an end game where there's a deal breakdown, either a concessionaire default or an authority default. More likely, the authority hasn't paid in that case, or the concessionaire fails to perform, and the lenders haven't cured. All the termination rights vis-a-vis the developer are subject to lender rights, and we have to make sure that that's codified in the direct agreement. But if there's a breakdown, what happens? Well, deal gets terminated, whether because of those events or some others on the next page, which include the extended relief events that we talked about. It includes insurance unavailability, just not an insurable deal, or the material portion of the deal is not insurable. A court could rule that the concession's unenforceable, or an impossibility to perform, or there's a convenience termination, which is a very important one to handle. If there's a convenience termination, it's a full make whole, right? Always, and that's very important. As to the remedies on the next slide, the base amount, this gets a little complex. So the basic idea here is with respect to concessionaire defaults, notably brownfield concessions, no compensation. That's a market difference from greenfield concession, where there's a haircut of about 20%. That obviously incentivizes cure in a brownfield scenario. I think the idea is that there's no real material construction. So from a market perspective, developers and their lenders have gotten comfortable that they can solve any problem that comes up without the deal breaking down entirely and everybody walking away in a concessionaire default scenario. And brownfield concessions typically just don't have that compensation. On these, in other formulations, so termination for convenience, granting authority defaults, no fault, lenders make whole. Lenders get made whole, including breakage costs. Your famous make whole is there. And that's the basic parameters. I think the notable point on the next slide is that there's a deduction regime for cash on hand that sometimes gets packed out quite thoroughly in negotiations. Frankly, is not always entirely reasonable, in my view, from the authority. That covers things like you subtract this from the termination payment, so credit balances that are pledged to the lenders. That seems reasonable as the lender's cash. But then you get into the murky area of insurance proceeds. Okay, are they received or could they be received? What are the permutations there that often gets negotiated? And then any other amounts the granting authority is entitled to set off. Well, what is that? It's market, but we gotta, oftentimes we'll be as concrete as we can about what those things are. And if it's a deduction for KPI breaches, understood. But if it's murkier, I think I get more concerned about it. Finally, Monica, where are we on time? Are we out of time, or do I have 2 more minutes? Can't hear you. I'm assuming I've got a couple of minutes. Yeah. Okay. So on certain risks, if we go to the next slide, this is sort of new market stuff, things that investors should pay attention to when they're thinking about investing in P3 transactions. Topic I've even been discussing just today on a transaction: appropriation risk. Always be mindful appropriation risk could rear its head with respect to a public granting authority, and it's appropriate to diligence the source of funding and what kinds of risk are associated with the obtaining of funding by the authority, either in the ordinary course or in a termination scenario that we just talked about. Same thing with sovereign immunity. Can limit and can exacerbate appropriations risk, and the parameters of that should be diligenced. And then finally, change of control, which is an interesting point we've been discussing with many of you in recent deals. The market is to effectively cede control of change of control to the authority. In the case of a change of control of your issuer, the authority will opine upon that under the concession, and to the extent that they consent to a change of control, then there isn't too much wiggle room for investors. Now, there's some carve-outs that could be negotiated in connection with a ratings reaffirmation to be assured that the change of control is copacetic or potentially permitted transfer provisions, but sponsors resist this. And that's a negotiated point, but that's an important element of the change of control regime to bear in mind. And then next slide, if we still have time, I think one of the things to bear in mind and this dovetails with what Mike was talking about for the commitment letter and the procurement process, is a lot of these deals, definitely the brownfield ones, but increasingly, and we're negotiating some of them now, the greenfield ones, the sponsors are of the view that there should be limited conditionality with respect to the implementation of the financing to mirror their no financing out limitations under the concession, which is sort of in this respect like an SPA. So they will squeeze down the scope of the representations and warranties that are conditions to close to certain limited representations and warranties. And I don't have time to talk about those, but it's something to bear in mind. They're called the specified reps, limited number of reps in the note purchase agreement and the concession. And the MAE concept is effectively a pass-through of whatever you've got under your concession. So the conditions under the model form with respect to representations and warranties and MAE are different in these deals than your typical deals. And there we go. Thanks very much for the opportunity to present.
I think you're on mute. I think you're still on mute.
Try popping in and out of session if you can't.
So I can jump in. Can you hear me, guys?
Yes.
Okay. So thanks, Lanika and Paul. So where Paul went and Mike went through a fairly broad, I'm going to go fairly narrow around construction finance, payment performance bonds, letters of credit, and a new creature out there, the expedited dispute resolution bond and the liquidity bond. So when we talk about construction finance, regardless of whether we're talking about a whole loan, building an office building, a CTL, or a P3, what you're trying to do in construction, right, is to build something to the agreed specifications and performance. Basically, you need to build what the owner is looking for. In a P3, it's generally a university, it might be a city, it might be an agency, and it has to be built to those specifications in order for the contract, generally, the counterparty to start paying. You need to make sure that it's built and delivered on schedule and within budget, because obviously for note holders, which have fixed payment schedules, making sure that that schedule is adhered to is critical, because what happens if it gets delayed beyond a certain period of time? Where do the notes get paid? And if it's not within budget, who's paying those extra costs? So those are key considerations. Dispute free, because disputes tend to extend time and they generally extend costs. So trying to get to a dispute free situation is not totally possible, but a well-built document is going to, with a lot of specificity around what is agreed to in terms of specifications and performance criteria, help get dispute free. And then, as Paul was saying, undertaken with proper risk allocation. For lenders, hopefully that means very little risk actually flows down to them, other than very narrow circumstances. So construction contracts, we're going to assume, as Paul had stated, that the construction contract in a P3 is a drop down. In other real estate, CTL, lease finance type transactions, you might have a GMP, guaranteed max price, which is an AIA contract, or a lump sum, not usually cost plus. Whereas P3s, for the most part, have that drop down, where literally you start with the project agreement or concession agreement, and you use that as the basis for a back-to-back contract to the contractor for all of the building and the construction aspects, and to the operator for all of the operations and maintenance services. So a well-made drop-down contract truly can be blacklined, and you can see what is going to your contractor. Next slide. Construction due diligence. I mean, this is very, very high level, but the lenders will generally have a technical advisor engineer look at the plans and the specs and the budget and the timeline to give some advice as to whether or not it's feasible. A feasibility type of study at the front end is very important to make sure that it seems like it's doable rather than overpromised. Environmental, for any lender or any developer, obviously anytime you're starting to I don't have geotechnical on here, but geotechnical would be the other. As soon as you start to break ground, not knowing what's underneath there is a surefire way to end up delayed and over budget if you are unsure if the ground is sufficiently firm enough to build on, or if there's environmental or anything else. Insurance, because again, that proper risk allocation. Insurance can cover a decent amount of risks if it is properly procured in the right amounts, and it is the right loss payees and insurance, additional insureds. Model auditor report, if for nothing else, to make sure once that contract comes online that the project costs can be amortized fully, and that the O&M costs for the building as it's built to spec are sufficient to pay for the cost. So a model auditor report in a P3 is very important to ensure that the revenue coming from, especially an availability payment, which doesn't generally have the ability for increases unless there are some of those factors that Paul had said, delay or compensation or relief events, but those aren't generally modeled in, and instead you have to look at the four corners of the expectations and make sure that that's modeled. And then mechanics lien searches, because it's a mechanics lien can be a nightmare for any lender, given the ability to prime liens and to come and all of the very Byzantine rules around them. So this is, I'm going to jump pretty quickly because this lays out fairly well the P3 security you expect during construction. And you see, you need a lender's long stop date generally. We'd love to see 6 months, enough time to complete the project if the developer doesn't, but we've had to agree to as few as 2 months in simpler projects. Expecting delay liquidated damages, making sure that you have a DB guarantee, that you have a credit-worthy contractor as part of that risk allocation. And then payment performance bonds, letter of credit ratings, making sure that the quality of your bank and your surety are high enough, because they can drag down the rating of your deal if you're getting a deal rated. And then there's retainage. Retainage is one of these quasi securities, because really it is intended to incentivize the contractor and not so much a pool of money to be available for liquid security, but it can kind of be used, and you have to be very careful if retainage should actually be used against a contractor or for a developer if it's not appropriate under the circumstances under state law. So now jumping to traditional PMP bonds. I think, broadly speaking, at times people think traditional PMP bonds are, I've heard people say, oh, it's a completion guarantee. It's not a completion guarantee. And really it's an indemnity, and has to be structured, frankly, as an indemnity for insurance compliance purposes. And it's a bond where the surety, and just reading this, assures the construction contractor, the principal, carries out the construction contract to the owner and sponsor, and the lender, the obligees. And one of the critical points, and an interesting point, sureties underwrite the bonds expecting they won't be drawn. They're not expecting they'll be drawn. So they're underwriting them not quite like you'll see a letter of credit. And so for a performance bond to be triggered, generally the principal, the contractor, has to be in default. The developer has to declare the default. The developer and the lender have to have performed. Sometimes that says fully perform their obligations under the contract, which is a very sensitive term, meaning, if we started to be in a dispute and the developer withheld a payment, during that dispute, have you fully performed your responsibilities? And in most bond forms, it says the obligee must terminate the contract, which actually leads to some anomalous results with PMP bonds. So the next. And so if those three requirements have been met, things are really going sideways with a PMP bond when you decide to call on it. And at that point, and this is a key, especially when we talk about the expedited dispute resolution, if the claim is determined to be valid, then the surety has to either complete, get a replacement contractor, or pay the penal sum. But the key there is that they have to determine the claim to be valid. There generally are not provisions for how long that time period is. And usually when people think about PMP bonds, if you don't think about it as a completion guarantee, people also throw up their hands and say they are just a claim. They're just a litigation, a cause for litigation, because that claim needs to be determined, and usually there's a dispute. So again, the drawbacks. One, their sureties are generally secondary. They're not financial guarantees. Claims on PMP bonds are traditionally seen as taking a very long time, delaying the claims. You have to generally declare that default. So it's not really, a PMP bond's not there to help. It may be a threat to declare default, but it's really not a workout type of document as much as it is, this is catastrophic. And due to the prolonged resolution times, people generally don't see them and are not credited as liquid security. Here's another point, and this is key to going back to sort of Paul's statement about your contract. A surety bond is only as good as your construction contract itself. And so you can't make claims against the construction contractor if they don't have those obligations under the contract itself. And so a well-drafted construction contract is very, very important. And things like warranties and liquidated damages and whatnot can all be captured by a surety bond, but they have to be in the contract itself. So what are the benefits? The benefits are that most people have seen surety bonds. They're comfortable with surety bonds. Oh, could you go back, Monica? I know you're pushing me a little, and I'll get there. So that principals generally have quick bonding capacity, and it doesn't affect the contractor's balance sheet quite as much as other security letters of credit. So letters of credit, I will jump quickly because most people know what this is. And basically it's equivalent of cash. People are very comfortable with the liquidity of a letter of credit. You are not bound per se by the construction contract. A bank isn't going to look at whether or not you have a claim to make it, as long as you make the claim. And then, sort of possession is 9/10, then you have to resolve whether or not you had the right. But you're able to generally make a claim against a letter of credit and pull the cash. All right, next. So we could jump through this. People know how liquid a letter of credit is. Drawbacks for the contractor are that and the reason why for developers, I'm sorry, contractors, letters of credit really hit their balance sheet, and they see it as an inefficient use of funds. So from our perspective, letters of credit and cash collateral are the highest and best, but the drawbacks for developers and why or contractors, and the reason we're seeing these alternatives are generally the cost and the leverage that they feel it imposes on them as a contractor. So now to the expedited dispute resolution bond. So this is a hybrid creature that the sureties, insurance companies, are trying to come out with in conjunction with contractors, to be honest. And I'm not sure developers are fully on board, and I'm not sure lenders are totally on board yet. But basically, it's a hybrid between some form of cash collateral or letter of credit and a surety bond. And let's go to the next slide, actually, to start talking about it immediately. So the mechanics are very similar to a traditional surety bond, and in fact, the issuer is a surety. They're all the main names that we would know. But as you could see from that first bullet point, 15 days after a demand, the surety must decide whether the principal is in default or there's a dispute. So right there's a difference between a traditional bond. That 15 days after a demand, they must make a determination. Now, one of those determinations is that there's a dispute. So obviously that could still throw it into a prolonged questioning period. And so are we any better than a surety bond when it's not that they have to make a payment in 15 days, they have to make that determination. And if they determine that the principal is in default, then they have very similar remedies as to a surety bond. They can remedy it, they can pull somebody else in, or they can arrange to make a payment. Next slide. So in the event that there's a dispute, because that's really what we want to know, how does this work if the surety says, no, we don't think that the contractor's in default? Well, then you go to a dispute resolution process that does have some fixed parameters around the timing of it. So there's generally about 30 days that a decision must be made, and it's binding on the surety, but parties can still, as you'll see, have a right of de novo appeal. So it's not a absolutely binding decision if there is a full appeal. If the surety fails to make that election, dispute or default, then it's deemed to be disputed. The disputes themselves are a jams, so some form of arbitration or mediation. Go ahead, next slide. And there are some timing there. Within 10 days, certain things have to happen, and then 3 business days later. Again, starting to put dated parameters around when these decisions need to be made. Not saying it's going to be made in the lender and developer's favor, but at least putting these parameters. And in the bond itself, it says the questions that the adjudicator must answer is, was this a default in the contractor's obligation? Has the obligee, basically the developer and the lender, complied in all material respects, and is the surety liable? And they must issue that decision within 30 days. There are additional extensions, that you could see that can be received, but for the most part, the sureties will tell you that it all can happen within about a 75-day gap. And so for their perspective, that's where this cash collateral rider comes in. And they're saying, look, it hasn't always been part of the EDR, but it's starting to be. And that is that the surety says, we will fund a cash collateral account in an amount sufficient to basically cover the 75-day gap. Now, what amount that actually is, LDs, delay damages, cap I, whatever it might be, those are important elements to figure out what goes into that 75-day gap. But nonetheless, to the extent that, yes, a dispute can be resolved within a fixed period of time, then the cash collateral rider, if properly structured, could potentially provide liquidity similar to a letter of credit or a cash collateral reserve. But there are defects that we're not really getting into. There are drafting defects, at least in the draft EDR bonds and cash collateral riders we've seen, So for example, still having to make a full demand on the bond, having to fully default the contractor, obviously some of the dispute things, this can still lead to, again, anomalous results or the unwillingness to really call on this expedited dispute bond unless things are catastrophically falling apart. Whereas a letter of credit, you're not necessarily, or a cash collateral reserve, you're not necessarily at catastrophic failure. And I think that's a key when we look at these EDR bonds to make sure that it's not black or white like a surety bond. Are we at catastrophic failure and we're calling on the bond, as opposed to more of a workout? So some of the, and again, it's a surety product, so I think the biggest concern is that do they have surety defenses even though they waive them in the EDR bond itself?
Hi,
So
David.
Yep.
This is Jay. I'm going to interrupt you real quick to read the second code. So the second code is 40225. Once again, that is 40225. Thank you, David.
Sure. So again, it is a very tailored, these are not off the shelf yet. They're highly negotiated and need to be negotiated if they're going to work. We do know that in some, the sureties have told us that they have done them in some of the deals that have been listed and have gotten credit as the equivalent of liquid security by the rating agencies. Not that that's a proxy for what we all do, which is much better underwriting, but just to know that the rating agencies are at some level accepting these. Liquid surety bond, I'm just going to quickly touch on this. We saw this in a public deal, and it may be a one of a kind. I don't know. There was one surety that issued it. My understanding is that it is issued in Canada in a form, but it was issued here in the US. And frankly, it read like a letter of credit. They had to pay. There were no defenses to payment, and it was based solely on a principal default, which it had to be, again, because otherwise it would be a financial guarantee. So there is another form out there from a surety that is a pure liquid surety bond, but that is going to take underwriting from the surety, and the contractor needs to essentially have that surety on board to make it work. Okay. How do we do? Where'd Monica go?
I don't know. Looks like we have.
So we'll open it up to questions. I don't think we'll have time.
We have 2 minutes left. So if there are any questions, Monica, do you have your sound again?
I do. I think so. I didn't want to leave until now because I was controlling the slides, and so I am now looking through. Apologies, everyone, for that text. It's been wild. So I am looking through. We're taking questions, you guys. We have 2 minutes. I am looking through the panel chat. The chat panel, and I am not seeing actually any questions. So if folks have questions, golly, there's 2 minutes. Let me see. And CJ, I don't know. I apologize, everyone. I don't know if I'm having difficulty scrolling down. I only see 2 of what looks like several comments. I don't know if any of you guys can scroll on the question and comment section.
I don't see any questions.
Okay.
Just congratulations and well done to
We made it.
Being the first.
So guys, I don't think that there's, we'd promised a quick, overview. Dave, I don't know if you wanted to do a quick overview of just some amendment and waiver terms that we're seeing generally right in the market with respect to the P3 space. I don't know if you wanted to quick give our spiel here in terms of where folks can find that.
Yeah, I mean, look, there was an ACIC panel recently, I think in
Dave?
August or July, that dealt with COVID waivers.
Looks like he paused as well.
Looks like he froze.
He's frozen. So I think everyone may know that, we planned on going through, and I don't think that there's enough time and kind of don't want to quickly push it through that, Dave Lasota's colleague, my former colleague, Charles Colin, did do earlier this year a CLE session on COVID amendment waivers and terms that would include some of the color here, color with respect to specifically P3s. So encourage you to take a look at that. I think it's very helpful. It's been great. We survived. without too many technical difficulties. Thank you, everyone, for the time. And guys, fantastic.
I mean, I would just say on the market, we're seeing a number of deals wind their way through the process, and despite COVID, so that's very encouraging. And we obviously look forward to talking with you about the items that we've talked about today, going forward. So are we still on?
We are still recording, so but we are now off session. So good job, you guys. Way to handle your mic problem, Monica. Good job, really good job. So, but we are still recording, but we are no longer live.
Okay, so if there are, I guess on that point, right, I wonder if CJ, so is the 5 minutes, just quickly right now, is the 5 minutes actually going to be what folks can turn to when they do the CLE? If people want to sort of post session do this for CLE credit, will this be on that?
Actually, people can still see us. So we are still live. So if people, so go ahead. If ask that again.
I just wanted to make sure. All I'm asking is if what we are doing right now. Yeah, and I'm seeing Dora just said you guys are still live. So look, I think that we've got 4 minutes, everyone. That actually 4 questions. I had anticipated. I had said to these guys before that I haven't been through a panel that's a substantive panel like this where there weren't questions after. So we had really truly saved the time for you all to ask questions. And I guess we do have time too, if there are any specifics. I know Dave had wanted to talk specific COVID. I can hear you, Dave. Yeah.
Dave, we can't see you. So if you want to try to pop in and out.
Can you hear me?
Yes, sir.
Okay. Yeah. Well, I think you won't see the developers raising their hand to pay a break fee. The procurement costs are already quite high. I mean, the equity guys spend a few $1 million. The contractors are spending tens of millions of dollars on procurement costs because they still have to submit, at least as part of the technical proposal, there's usually some certain element of the design that has to be submitted, and the designers don't work for free. So, people are spending a lot of money on these procurements, and the stipends that the authorities are paying are quite small in comparison to, to what the actual costs are that go into submitting a proposal. So until you see those stipends really step up from the authority, I don't think you're going to see any type of break fees paid. It's unfortunate. I mean, there's other ways to handle it and to address deal certainty. I mean, you see it in the M&A context a little bit with staple financings, and in some types of transactions, a land availability payment transaction, a staple financing might actually work well. It puts a lot of focus on the construction price, but it might actually work. I mean, to a certain extent, TIFIA is a staple financing in the way it's usually incorporated into a procurement. It very much acts that way, right? Because there's a common term sheet that everyone's bidding on and things like that. So there are ways that the deal certainty could be improved upon, but I don't think a break fee is ever going to happen. You can try.
Yeah, unless there's a change of mindset at the authority level,
right?
Which is these days probably extremely unlikely. But you never know how the market emerges in the next couple of years.
Yeah.
There's nothing else coming in, guys.
So we can leave session. Thank you guys so much.
Thanks, everybody.
Bye-bye.